Your Honor, this is Cornelius Yarber on page 7, docket 19029.
You represent Mr. Yarber. Mr. Yarber, you're represented by the public defender, and this is here for a hearing on a violation of probation. Are you?
Yes, sir.
Judge, I didn't know that I had Mr. Yarber. I thought this was an arraignment. I think he thought so as well. If I can just second call Yarber, let me figure that out.
Mr. Yarber, we're going to let the public defender who's been appointed to represent you have a moment to look over your case. So we'll come back to you a little later in the morning. Thank you.
Yes, sir. Thank you.
Page 6.
Why?
White. What's her name?
Your Honor, this is Justin White on page 6, docket 19391.
Who is this judge? I'm sorry. Is this Mr. White?
Yes.
Okay, Judge, we had filed a motion to withdraw on this. We've got a conflict in this case. I believe we represented the decedent. I called the board professional responsibility and they said our office needed to get off of it.
All right, the public defender has filed a motion to withdraw in this matter, so I'm going to appoint Mr. Spencer Hamlin to represent. I don't think Mr. Hamlin is here, but I'm going to appoint Mr. Spencer Hamlin. Mr. White, I'm going to have to appoint a different attorney to represent you because the public defender has discovered that they have a conflict. So actually, I need to change this, not Mr. Hamlin. This is a second-degree murder trial charge, is that correct?
Yes, sir.
All right, I'm going to appoint Mr. Scott Saul to represent them on the. Mr. Saul will be notified. Let's go ahead and I think it's actually set on September the 9th. September the 17th is set for trial, and the last day for a plea is September the 9th, but let's put it on a status day. Who is September? And when is she next year besides September? All right, I'm going to put it for status on May 13th. Make sure that Mr. Saul is here and involved in the case. So your lawyer will be notified that he's going to be representing you. He's an experienced attorney. He'll be in touch with you and get your case ready for trial in September. But I'm going to have a status day for you to come back in front of the judge who is supposed to try your case in May 13th. And that way you and Mr. Saul can both let the judge know if you're ready for that September trial date. All right, thank you.
So see. Your Honor, this is Daniel Bustard on page 1, docket 19394.
Well, your attorney's not in the courtroom at the moment, so we're going to ask you to let us come back to you on the second call. Thank you.
All right, thank you. Your Honor, this is Tyler Dang on page 2, docket 19347.
Judge, I represent Mr. Dang. I believe he's got an amended VOP that he needs to be served on, and I think that it was stemming on charges out of Davidson County. Okay.
All right, there is an amended violation of probation warrant that's been issued against you, Mr. Dang, and your lawyers indicated that it needs to be served on him, I suppose, or you actually. And do you want to go ahead and arraign him on that?
Yes, Judge, we'll enter plea not guilty on
Plea of
that.
not guilty is entered. Do you want to set this then for next month?
Can we set it for May, Judge?
Pardon?
May.
May 3rd, what would be VOP day now? May 27th. Dang, your lawyer's going to get a copy of the new warrant for violation of probation, and he'll be ready to have your case heard in May. Thank you.
Your Honor, this is Jeremy Brewer on page 1, docket 18561.
All right, Mr. Brewer, you're here to be arraigned on a charge of violation of community corrections. You have the right to an attorney. Do you wish to have a lawyer represent you?
Yes, sir.
All right, I'm going to appoint the public defender, and I'll give them a copy of that affidavit. Do you wish a formal reading of that?
No, Judge, we'll enter plea not guilty on that.
All right, plea of not guilty is entered. You want it set for
May, okay.
set
May,
for
Judge, if that'd be all right.
May 27th. Your lawyer has been appointed. He has a copy of the charges against you, and he'll be over to talk with you. And we've set a hearing in your date, in your case on May 27th. Thank you.
Thank you.
It's James Boyce on page 2, docket 18905.
Judge, I represent Mr. Dubois. He's got pending charges out of Dixon County. I believe those are set in May, if we can get that May court date as well.
All right. Do we need to do the May 27th?
Yes, Judge. I believe his court date's May
Right,
5th.
May 27th. Your lawyer is working on your case, but we need to reset you for May to be able to get all of this together. So he'll be in touch. Thank you.
I think my court date in Dixon is May 28th.
Okay.
Up.
Then we'll just put it on the July docket then, Judge. Can we put it on your July docket?
What?
Well, we can put you on May 27th. Well, that would be the day before his case is in July. All right. What is our deal? July?
To do 29th?
June day? June or July?
We can do June, and if something changes, Mr. Dubois, I'll come see you and we can get you moved back up.
Okay.
Are you assigned to a particular court?
We were on.
Yes,
All
Judge.
right, well, let's put it in July,
Oh my God.
July 22nd. That'll give you a chance to get your case in Dixon County resolved, and then they'll work on your VOP. All
It
right,
should be took care of in May. They said they have a deal in May.
And if that's the case, JT, I'll bring you over here sooner.
All right, appreciate it.
All right.
Thanks, sir.
Right there, have it for him. So, see. Your Honor, this is James Doris on page 2, docket 19503 and 19537.
Judge, Mr. Doris, we put him on the docket today for a potential plea. Dr. Bidding came and saw him Friday and then did his evaluation. He spoke to me and kind of gave me some of those results. I'm awaiting his actual findings on everything. If we can just keep his status day in July, and between now and then, if I can get something worked out, I will.
all right, well, the status date is already in July, is that correct?
I thought it was the 8th.
July the 8th?
Thought it was, maybe not. Okay.
Well, we'll set it for July. All right, July 8th.
I'll come see you, Mr. Doris.
What did you say?
I'll come see you, your attorney did.
My attorney will come and see you,
That's what he said, yes, sir.
no date.
Not specific. No, sir.
All right, Mr. Doris. You've got one, please.
Bruce Johnson. Yeah, great. Mr. Johnson.
Is it?
Have a seat. Your Honor, this is Scott Dotson on page 2, docket 17471.
Judge, I represent Mr. Dotson. He's got pending charges out of White Bluff, and I believe he had a pending amended VOP as well.
We have an amended VOP that he needs to be served with, or actually has been served with. I'm going to give you a copy of it, Mr. Vaughn. And we'll enter a plea of not guilty. So when do you want to set this?
The May date, please, Judge.
May 27th. All right, your lawyer's working on your case. He'll be able to talk with you and get you ready, but we're setting a hearing on May 27th so you can resolve all your other cases.
Okay, you said something about a bond hearing today too, sir. I can resolve my situation in White Bluff. It's one charge. And if I could get bonded out, I could resolve a lot of it and hire my own attorney is what I would like to do.
Do you want him brought over for a bond hearing?
No, Judge, we can do that later. I haven't filed anything.
All right. Mr. Vaughn needs to talk with you about your bond situation, so we'll come back to you. But Mr. Vaughn needs to talk with you about that before we have a hearing in a bond. There's nothing filed at this point in time, so the public defender will need to file something and get that heard.
Yeah. Next time it's in here.
Make sure everybody's here.
Walker? All right.
Yeah. I'll go out there. Okay. All right. Walker. No. Your Honor, this is Andrew Walker on page 6, docket 19598.
Walker, this is set for today for a hearing on your violation of probation, but previously you had indicated that you had the ability and were planning on hiring a lawyer. Have you hired a lawyer?
Yes, sir.
All right,
Yes,
Mr. Lockhart is your lawyer.
He hired me and it's for a disposition.
And are you ready to proceed or do you need him?
I'm ready to proceed.
All right, or is this going to be for a hearing?
No, Your Honor, he's going to plead guilty. He'll be extended 2 years.
So he's going to be plead guilty, be revoked to serve a sentence, but suspended on time served, reinstated on time served, and extended for 2 years.
Yes, Your Honor, he'll, instead of 4 years probation, he'll have 6.
All right. Mr. Walker, let me ask you to make sure that you understand. Raise your right hand. First of all, let me place you under oath. You solemnly swear from the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, thank you. You can put your hand down now. State your full name for the record.
Andrew Austin Walker.
Mr. Walker, you're here today charged with probation violation. Your lawyers indicated what the agreement is, but I want to make sure you understand your rights. Do you understand that you have the right to plead not guilty to this charge and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand that you would have the right to have a lawyer and to have one appointed if you could not afford to hire your own lawyer?
Yes, sir.
You understand if we had that hearing and I found you guilty, you can appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to that hearing and to that appeal. All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
And you understand that's going to mean that you're going to be reinstated to probation, but your probation is going to be extended for an additional 2-year period. You understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, Your Honor.
You want to plead guilty according to this agreement and waive your right to that hearing.
Yes.
Then upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but by agreement with the state, you will be reinstated to probation on time served and extended on your probation for an additional 2-year period. When you're released, it will be up to you to go immediately to the probation department and check in with them so that you can start reporting again, okay?
Yes, sir.
All right, thank you.
Thank you, Your Honor. Your Honor, and while I'm up here, James Standifer, docket number 19319. His family has hired me. I've got a substitution of counsel order being prepared right now.
That's on page 5.
Yes, Your Honor.
All right. So instead of Andrew Lockhart, it will be Mr. Jake Lockhart.
Yes, Your Honor.
What are you wanting to do? This set for a hearing today? Are you ready?
It'll be for hearing.
All right. Do you need him brought over from the jail?
I prefer to do it in here as
All right,
opposed to
we'll need
Zoom.
Mr. Standiford brought from the jail over for a hearing later this morning.
Thank you, Your Honor.
All right.
Your Honor, this is Jonathan Williams on page 6, docket 19702.
Let me get your file. So hold on just a second, please.
Yes, sir.
This is an arraignment. Mr. Williams, it's my understanding that you have hired a lawyer for your Dixon County case, Ms. Rhonda Crabtree or Myers, and that you have not yet hired a lawyer for this case. Is that correct?
Sir, right now in Dixon, they furloughed me to rehab in Memphis. And there's a hold in Cheatham, and they're not gonna let me go do it until I get this hold off of me. It's for 190 days, and that's what I'm needing to get live, but I plan on getting a lawyer, sir.
Well, this is a case, this is here on a charge of casual exchange and possession of drug paraphernalia. And it is here for an arraignment. And what does he have a bond? I need to get your file and we don't have it. So if you'll just bear with us, we'll come back to you a little later in the morning. We'll try to sort this out.
Yes, sir. Thank you.
All right.
Your Honor, this is Christopher Stokes on page 6, docket 19708.
Mr. Stokes, you are here to be arraigned on a charge of second-degree murder. You have the right to an attorney. Do you wish to have a lawyer represent you?
Sir?
Do you want a lawyer to represent you?
Yes, sir.
All right, I assume you're not able to hire a lawyer of your own since you're in custody, correct?
Correct, sir.
All right, then I'm going to appoint the public defender's office to represent you. We will give them a copy of the indictment. You wish a formal reading of that indictment?
No, Judge, and we also, Miss Julie said that we have a conflict with this case.
You have a conflict with this case?
Yes, sir.
All right, I'm going to appoint Mr. Andrew Lockhart of the Stephen County Bar to represent you at this case. Let me go ahead and arraign you on the charge. This is in the Circuit Court for Cheatham County, Tennessee at Ashland City, March term, grand jury 2025. Grand jurors of Cheatham County, Tennessee, duly impaneled and sworn upon their oaths do present that on or about December the 21st, 2023 in Cheatham County, Tennessee, prior to finding of this presentment, Christopher B. Stokes, then and there, did unlawfully, knowingly, and feloniously kill another, to wit, Ashton M. McGowan, by unlawful distribution, delivery, or dispensation of fentanyl or carfentanil, when those substances alone or in combination with any substance scheduled as a controlled substance by the Tennessee Drug Control Act of 1989, including controlled substance analogs, is the proximate cause of death of said user, to wit, Ashton M. McGowan, in violation of Tennessee Code Annotated 3913-210, subsection A3, a Class A felony, which is against the peace and dignity of the state of Tennessee, signed W. Ray Krause Jr., Dixon District Attorney General, show that he has been arraigned and that I have appointed I believe I appointed Andrew Lockhart, is that correct? Andrew Lockhart has been appointed. Mr. Lockhart, now we'll set it for status. Is this a case that, Mr. Lockhart, I'm sorry, I didn't see you standing there. I would have let you waive the formal reading of the indictment.
I'm sorry, I missed that last part, Judge. What was that?
His name is Christopher Stokes.
Okay.
And let me give you a copy of the indictment. Now, he's now been arraigned, so we need to set status for General Segi's case. So you want to set it next month on April 15th for status? April 15th for status.
Thank you, Judge.
Your Honor, the victim in this case is a very close friend of our family's. We helped to try to get him in treatment numerous times. My wife worked with his mom for a long time. It would be very awkward for anybody in our office to represent anybody, and I just think the appearance would not be good.
All right, I would agree. I think in a serious, this serious of a charge, we don't need to have any issues that would be dealt with. So
Okay.
we will allow you to be released.
I was unaware of that, Judge, but that's fine.
Well, I will appoint Mr. Vid Sanker, who is requested to be placed on our appointment list. And Mr. Sanker will be appointed. We have a card for him. And your lawyer will be in touch with you after he's notified of his appointment. We are nonetheless going to set you on April 15th for status so that Mr. Sanker and you can have a chance to talk about your case and see what the status of it is, and then we'll go from there. So we'll see you in court on April 15th. Your lawyer will be in touch between now and then, to get you ready for status. Thank you.
And you said his name was what, sir?
His name is Vid, V-I-D, Sanker, S-A-N-K-A-R. He'll
Thank
be
you,
in
sir.
touch. Thank you.
See right there, sir. Your Honor, this is Kevin Clark on page 2, docket 19706.
All right, Mr. Clark, you're here to be arraigned on the charge of second-degree murder. You have the right to an attorney. Do you wish to have a lawyer represent you? Are you able to hire a lawyer of your own choosing?
I'm gonna get in contact with my people whenever I get the chance to use the phone.
I didn't understand. I'm sorry, I did not understand you.
I'm gonna call my family when I get a chance to use the phone and I go from there.
Gonna call his family. I think he's indicating that he's gonna hire an attorney.
Well, you plan to hire a lawyer of your choice, is that correct?
I'm gonna try, sir. Yes, sir.
Well, this is a serious charge. Right now, you're in custody. I can appoint the public defender to represent you so that you have counsel from this point forward. And then if you're able to hire your own lawyer, then we can just do an order of substitution. Would that suit you?
Yes, sir.
All right, then I'm going to appoint the public defender.
We'll acknowledge receipt, waive formal reading, enter a plea of not guilty, judge.
Plea of not guilty is entered. We need to set this case. All right, so this will be set on April the 15th. So if you have a chance to hire a lawyer, be sure to do that before April 15th. And in the meantime, the public defender will be working on your case and they'll come over and talk with you about it, okay?
Yes, sir.
All right, thank you. April 15th.
Your Honor, this is Johnny Bogle Jr. on page 1, docket 19100.
Your Honor, this is my client, and we had previously put a sentence into effect to furlough him to Morgan County Drug Court. We got him in there, and he has a hold out of Davidson County, which we can't get him to pick him up. In the meantime, the parole board would like to parole him, but they can't because of the furlough. So he's requesting that the furlough to treatment now just be.
So the furlough is a perfect example of what Judge Martin used to always tell me, don't ask for something you're not sure you want because you might get it.
Oh, we put so much work to getting him into Morgan County and then couldn't get him transferred, and it.
So I need to cancel his or revoke his furlough.
Yes, sir, please.
Right. His furlough is hereby revoked.
Did you hear that, Mr. Bogle?
Yes, ma'am.
You're finally through with Cheatham County, sir.
Okay, what happened?
Now, you're through with Cheatham County now.
Okay.
Good to see you.
Furlough is revoked, so we'll let you deal with the other county, what you need to do, or with the Department of Corrections. Thank you.
Okay. That is? Huh?
Yeah, that's it. You ready?
I'm through with Cheatham County.
You still have your TDOC down is what you're saying.
Okay.
Joe?
Yes.
Sounds good, sir. Your Honor, this is Terrence Young on page 7, docket 19490.
Judge, if we can reset Mr. Young, he's got pending charges, I believe tomorrow in Judge Maxey's court, with Mr. Richter.
All right, so in order to allow him to try to resolve his pending cases, you want to reset his violation of probation to when?
May would be fine.
May 27th. Mr. Young, your lawyer wants to try to resolve your pending cases, which are also would have an effect on your violation of probation. So we're going to reset your violation of probation for May 27th. And Mr. Vaughn will continue to work on your case.
Okay, if I get the case taken care of, can I get my VOP pushed up?
Yeah. Yes.
All right, thank you very much, sir.
All right, thank you.
Your Honor, the rest of the names on my list we were already advised need to be brought up.
We can handle Mr. Yarber from the first call.
All right, Mr. Yarborough.
There's all y'all. Meet him again.
The docket that I had, Judge, and have been working on indicated that he was in arraignment. I suppose that was last week. He was being supervised out of state, and that officer did not know to be here, so I don't know that the state or anybody can move forward with that today. If we want to just put that in April.
All right, so Mr. Cornelius Yarborough is going to be on April 15th. All right.
We have a copy of the docket.
All right. And if you'll just advise, we'll allow the public defender to advise Mr. Yarborough, we don't need him. We're resetting him for April 15th. Yeah, I'm sorry. What is that? April 29th is the VOP day, Mr. Vaughn. Oh,
April 29th?
April 29th, that's the VOP day.
Fair enough, Judge.
Mr. Sanders, if you can hear me, I need you to unmute your device there so I can hear what you're saying. You'll still need to unmute it. I'm not sure if there's on your computer or whatever that's there.
The judge said he wants me to unmute it. I can't get to the screen.
Mr. Sanders, I can hear you now.
I can't get to the screen to put the unmute, you know what I'm saying?
A miracle of modern technology.
Oh, well, it wasn't there on the screen.
Mr. Sanders can come back in front of the screen. I can hear what he's saying. Mr. Sanders, you have filed a motion or a document with this court stating that I, Brandon Sanders, would like to file a post-trial relief motion to regain lost good days and or hopefully receive a kill sentence, time served. The alleged victim, Shelley Knowles, does not live at the address where the alleged crime occurred. My dear friend of 20 years, Miss Jan Hayden, does. I don't understand why good time was taken for writing Ms. Jan. I am more a victim than Shelley. She robbed me of about $500 and time by living. I lost a lot. I am just ready for this to be over. I have joined Project Return, and it sounds like they have an amazing program. As soon as I can get out, I should be back on my feet soon after. Sincerely, Brandon Sanders, dated 3/3/25. Love and respect is at the bottom. So I am trying to determine exactly what it is that you're asking for this court to do.
Can you hear me?
Your probation was revoked by Judge Lockhart Nash at a hearing in January of 28th of 2025. And she is the judge that this matter will have to be heard in front of. So I'm going to set you in front of Judge Lockhart Nash for her to determine whether or not there is a basis for any relief that you may seek. And what would be her VOP date? What? May 27th? Your date will be May 27th in front of Judge Lockhart Nash.
Yes, sir. Thank you.
All right, thank you. Anybody else there at the jail that I need to deal with?
Your Honor, we have Daniel Bustard I saw his attorney was in the courtroom now. I didn't know if you wanted to
All
see
right,
him.
Mr. Locker. All right, let's do that. Daniel Bustard.
Yes, Your Honor.
Bustard.
We've got an agreement. We're working to get him into a drug treatment program. That should be done fairly quickly.
May 13th, next date that I would have. I know it'll be a conflict, but I'm in agreement to waive it. He is, it's just an out.
Mr. Bustard, your lawyer says they're working on resolving your case and getting you into a treatment facility, and that they've asked that it be placed on May 13th for them to try to finalize the arrangements to get you into treatment. So I'm going to grant that request to move it to May 13th.
Yes, and Your Honor, we may actually try to get that set on April 15th if we can get all the
Well, that's
paperwork and
fine.
everything. in
If
order.
they can get it, if they get everything worked out, they may bring you up earlier than that May 13th date and get you in front of a judge to get it approved.
All right, thank you.
Thank you, Judge.
Thank you.
Your Honor, the rest of the names on the list, we were told need to be brought up before you, when you're ready.
All right, thank you. Let's move into the regular call of the docket. 2024 CR 19633, State versus Terrence Jr. Biggs.
This was placed in the docket by myself and Sonny Stevens in order to enter a settlement. It was placed over a month ago. Ms. Margaret Brady is sitting in or standing in for Ms. Stevens right now. I'd ask the second call that before asking for a capias on this. I'd like to resolve it today, but if he's not here on a second call.
We'll put it on a
pass
second call.
Thank
Thank you. 2020 CR 18980, State versus Ryan C. Bowden, Public Defender.
Judge, I represent Mr. Bowden. It's my understanding that he's in custody in Davidson County. He was to be transported today, but I think that didn't happen.
All right, so what do you want to do?
I would like to, can we put him on an April date and get a transport for him? And I'll come back and, I believe he just wants to put his sentence into effect.
April 29th, is that the date? April 29th.
Yes.
We had a Christopher Bracy that was in custody that you had a drug court application status.
Yes, Judge, Mr. Beecham came and interviewed him this morning. I believe they're going to vote on him tonight. Mr. Bracy knows that we're going to have to wait until April to get this done.
So April 29th on Mr. Bracy as well.
Can we do it earlier than that? Is there an earlier date in April?
All right. April 15th.
Yes.
2024 CR 19564, State versus Jonathan S. Brewington Jr. Mr. Atchison.
Judge, that's my point. He's present. Second call, she's doing it, and I will be at that result.
Second call. Page 2, we have a 2023 CR 19474, State versus Brianna Cox. It
Judge,
shows she's in jail.
I think she was transported, but we've got that resolved as well, Judge.
All right, so you're ready for her if they have her?
Yes, sir.
Let's find out if we've got Ms. Cox in. All right, so we just need to bring her up, then, correct? 2024. Let's see, we dealt with Mr. Doris. And 2022 CR 19333, State versus Angel Gowan.
Judge, that's going to be for plea, Your Honor. Are you ready to hear that, Judge? Judge, Ms. Gowan is charged with vehicular homicide. This is an older case, but after speaking with General Arnold and General Stevens, we've come to an agreement that this is going to be amended to reckless homicide, a D felony. It'll be 6 years suspended to supervised probation after serving 1 year in the Cheatham County Jail. She does have significant credit for that. And of course, no contact with the victim's family. I believe that she has from 6/20/2022 to 11/7/2022 worth of jail credit. It's a D felony, and as part of the agreement, we're pleading her to 6 years. We understand it's as a range one, but only the amount of years is out of range, Judge.
All right, Ms. Galvin, raise your right hand. Let's place you under oath. State your full name for the record.
Angel Elizabeth Gowan.
Ms. Gowan, you are here today charged with a number of offenses. You've heard the public defender state what your agreement is with the state, and it's indicated that you're going to be entering a plea of no contest or nolo contendere. What that means is that you're not going to admit you did anything wrong, but you're not going to deny the state's evidence or not contest it. And as a result, the state will then tell me what their evidence would be if this case went to trial, and that evidence will support a finding of guilt against you in this case. Do you understand that?
Yes, sir.
You understand what you're charged with, and have you and Mr. Vaughn had a chance to go over all the charges, talk about what the evidence is and the range of punishment you're facing on all the charges?
Yes, sir.
Well, it's indicated that you want to enter this plea of no contest. Do you understand you have a right to plead not guilty to all charges and have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that you, in fact, are set for trial, I think, later in the year on all of these charges? You
Yes, sir.
understand that? Do you understand that you would have the right at trial to have an attorney and to have one appointed, as we've done with the public defender?
Yes, sir.
Do you understand at trial you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that at trial you and your lawyer could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by using a subpoena? Do
Yes,
you
sir.
understand that if you went to trial, you'd be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
But do you understand that's going to result in a Class B felony conviction that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you wish to waive your right to a trial and to an appeal by entering this plea of no contest?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand that I cannot accept this plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these crimes?
Yes, sir.
And I want you to listen as the state comes to the podium and tells me what their evidence would be if this case went to trial. Mr. Stevens?
Your Honor, the state would intend to show at trial that on or about June the 20th of 2022, Trooper Aaron Ronker responded to a motor vehicle accident in Cheatham County. Based on the investigation, Trooper Ronker found that a minivan driven by the defendant crossed the center lane and struck a vehicle driven by Sophia Paulette Hendricks head-on. The crash ultimately caused Ms. Hendricks' death. Trooper Ronker did observe signs of intoxication, although an EMS staff on hand provided that he did not. Ms. Gowan did have active clonazepam in her system, and this is a settlement reached on the totality of all of the evidence. The victim's daughter is present. She does not wish to provide a statement, but is here to observe the plea.
All right. I'm not asking that you agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
Do you still wish to plead not guilty or no contest rather to this charge?
Yes, sir.
Are you satisfied with your attorney services?
Yes,
You
sir.
feel like your lawyer has done a good job of representing you competently?
Yes, sir.
And it's my understanding that this plea is, Mr. Vaughn, is outside the range, but is still as a range one offender, correct?
That's correct.
And that's part of the agreement. All right. Mr. Vaughn, do you know of any reason she should not enter this plea?
No.
Anything further from the state? All right. My understanding, this is being entered with the agreement and consent of the victim's family, correct? All right. And Angel Gowan in docket number 19333, upon your plea to the amended charge of reckless homicide, I find you guilty, sentence you to 6 years in Tennessee Department of Corrections. That will be suspended to supervised probation after you have served 1 year of the county jail. You will get credit for time served. You'd have no contact with the county, with the victim's family. Your pre-sentence jail credits are set forth here. She will have time to serve, correct? Remaining.
She will have probably about 4 or 5 months left. She's.
Right. All right, then,
She needs to be with probation.
all right, she needs to talk with probation. She'll be remanded to the custody of the sheriff's department following that
Thank
to
you.
begin serving the sentence. Thank you. 2024 CR 19564 State versus Gary W. Henson. All right. You know, when is his next day? Does it matter? Eric Henson. I think we're talking about Henderson versus Henson. That's all right. Henderson is the one that was set for the 20th. So Gary Henson, who has a lawyer in Montenegro.
Mr. Henson, the co-defendant, Mr. Brewington, so I think that's the second call with Mr. Atchison.
All right, so this is his status date to plead or go to trial. And what did you say his co-defendant is?
Mr. Brewington, represented by Mr. Atchison, should be okay.
And what did we do with Mr. Brewington without me having to look back?
Mr. Atchison asked for second call. They're both talking.
Um,
They're waiting for the verdict application.
Second call. All right, thank you for that information. Mr. Vaughn, you have something?
I anticipated Eric Henderson being called next, but
We have a Dandries M. Jenkins that's in jail at 2022 CR 19309. Anything to report on that?
well, I believe there was an amended VOP for Mr. Jenkins that's going to be filed today. We had that worked out, but now we don't. So
So,
I guess he's going to need a May date. The charges that came up were fairly serious for the amended, but I guess he needs to be served with it.
all right, we need to serve him with that. We'll set it for the May 27th date. 2016 CR 18004 State versus David S. Johnson. Ms. Fordyce. Morning.
We have a plea arrangement. I've gone over, it's agreed if you'd rather do it on second call.
Doesn't matter to me. You let him look at it and make sure.
On the VOP, he's gonna plead guilty. It's gonna be reinstated to probation. And on the new charge, he's gonna be pleading guilty to simple possession. That is gonna be consecutive to this sentence, also on probation. He's been doing really good. And I need the DA to sign.
All right, Mr. Johnson, raise your right hand. Let's place you under oath.
I do.
State your full name for the record.
David Shane Johnson.
Mr. Johnson, you're here on two different types of cases, so I'm going to explain them differently to you. On the probation violation, do you understand that what you're charged with? Do you understand you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
Do you understand you would have the right to have a lawyer and have one appointed if you could not afford your own?
Yes, sir.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that if you enter this plea, you're waiving your right to that hearing, to that appeal? All I'm going to do is approve what your lawyers worked out, which is basically to reinstate you to probation.
Yes, sir.
At this point in time. Do you understand that?
Yes, sir.
Do you wish to waive your right to a hearing and enter a plea of guilty on the charge of probation violation?
I do.
Then I find you guilty of your probation violation or that you be revoked to serve your sentence, but by agreement with the state, we will reinstate you to probation. On the next case, you understand that you're charged with simple possession and that you have certain different rights. First of all, do you understand what you're charged with? And have you seen or been shown a copy of those charges? And you and Ms. Fordyce talk about what you're charged with, the range of punishments you're facing, and any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of, is a guilty plea on that charge, no contest.
I think I checked no low content rate, but either way, it doesn't. Did I?
It is no contest. I couldn't see it without my glasses. And do you understand that a no contest plea means you're not going to admit what you did? You're not going to contest the state's evidence. They're going to tell me what their evidence would be in this case. And I would use that evidence to find you guilty. You
Yes,
understand
sir.
that? Do you understand what you're charged with in that case?
Yes, sir.
Do you understand you have the right to plead not guilty and to have a speedy and public trial by jury in that case?
Yes, sir.
Do you understand that you would have the right to have a lawyer represent you at trial, and you would have the right to have one appointed if you could not afford your own?
Yes, sir. Yes, sir.
Do you understand at trial you'd be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that you and your lawyer could confront and cross-examine all witnesses the state called at trial, and you would have the right to have your own witnesses come in by the use of a subpoena?
Yes, sir.
At trial, do you understand you would not have to testify or prove anything? You would be presumed to be innocent, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you were found guilty at trial, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out.
Yes, sir.
That means that another conviction, a misdemeanor conviction, will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand that's going to run consecutively to the charge that you've just been placed back on probation for? So you're going to actually have that original sentence, and then this 1129 will be hanging over you beyond that. Do you understand
Yes,
that?
sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you wish to enter a plea of no contest according to this agreement and waive your right to a trial?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty?
Yes, sir.
And listen, as the state tells me, whatever their evidence will be if this case went to trial.
Yes, Your Honor. Docket 19694 on November 7th, 2024, Officer Goblin with Pleasant View Police Department was patrolling around the area of a 240 Bryn Mawr Center Drive in Pleasant View. He noticed that Mr. Johnson's vehicle was set apart. He approached the vehicle. When he did, he noticed that Mr. Johnson had his pants undone and his zipper down. He asked for consent to search the vehicle. Mr. Johnson stepped out of the vehicle. He then asked Mr. Johnson to step toward his patrol vehicle and asked him if he would empty his pockets. He did pull out a white powdery substance. After he was Mirandized, he, I believe once he pulled it out of his pocket, he just blurted out, "I'm going to jail." And then he said he got the drugs from his girlfriend, approached Miranda, and that he did admit to having drugs in his pocket.
All right, I'm not asking that you agree with those facts, Mr. Johnson, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead not, no contest?
Yes.
Are you satisfied with your attorney services?
Yes, sir.
I feel like Ms. Fordyce has done a good job of representing you competently.
Yes, sir. Great job.
Ms. Fordyce, you know of any reason he should not enter this plea?
No, sir.
Anything further from the state? Then David S. Johnson, docket number 19694, upon your plea of no contest to simple possession of a controlled substance, I find you guilty, sentence you to 11 months and 29 days in the county jail that would be suspended to probation by agreement with the state and will be served consecutively to the prior case of probation violation that you were reinstated to probation. You'll need to see probation before you leave today.
Yes, sir.
Thank you, sir.
You're welcome. We also have a person in jail 2022 CR 19363, Drake McCroskey, public defender on that one.
Yes, Your Honor, I've got Mr. McCroskey. That's going to be, we've got that one worked out. That will not be for hearing, but he does need to come up.
All right, bring up Mr. McCroskey, so that will be on second call. Mr. Fordyce, I think you were waiting on the next case, Robert L. Moss on page 4.
Yes, Your Honor, we were not aware of something out of Davidson County. And talking to the general, we're requesting this be set to the July date. What's it, July or June?
You can bring your order in July.
All right, so this would be July the 8th.
Thank you, sir.
All right, July 8th. We have in jail a Clifton Lee Phillips.
Do judge, that one is also worked out. He just needs to come up and
All
admit
right,
he's
bring
in
up
violation.
Mr. Phillips. What about Joshua D. Porter, the next one?
Josh, that's the only potential hearing I could have today. He's being brought up.
We need to bring him over as well. Okay. All right, on page 5, 2023 CR 19524 State versus Lisa Pressgrove.
Judge, that's Mr. Richter's case. He indicated to me that he just needed a trial date on Judge Turnbow's calendar, which I believe is April.
General Sadie has requested on June 3rd.
And is that the same vote for Mr. Till? June 3rd. We already do Phillips. Here's number on page 6, 2024 CR 19596 State versus Brittany Danielle Trice. Trice. So you're requesting to change the program that you're involved in. Is this through the probation department? Are you on
Yes, sir.
probation right now?
Yes, sir.
Who is your probation officer? Do you have any opposition to her changing the program? All right, and we'll order that you're be allowed to change the program. If you'll just coordinate with your probation officer so that you can get into a program that's covered by your insurance, I think that's a reasonable request. Okay. So I will approve your changing the program to something that she can be covered with. Her insurance will cover it. And just talk with the probation officer, let her know what you're doing or what program you need to get into, and I'll approve the change. Okay.
Okay, thank
All
you.
right, thank you. It's like on docket numbers 2016 CR 18010 State versus Michael D. Williams Jr. Williams, this is here for a review of your payment status. You are now paid in full according to this document. They have any, this is a probation violation based upon payments. Do you have any opposition to dismissing it now that he's been paid in full? All right, probation violation is dismissed upon your full payment. Thank you.
All right, thank you.
It's like page 7. I didn't think you would be. on the Curtis Day case, General, when did we set that for?
4/11.
4/11, it'll be set in Dixon County on, April the 11th. We'll need to deal with that, so. All right, now it's 2024 CR 19573, State versus Eric Lavoy Henderson.
Judge, I represent Mr. Henderson. This is the one we talked about in chambers, where I was requesting a status date for July. Mr. Henderson has multiple cases that are all pretty serious. We would ask for a July 8th date. However, as Your Honor knows, General Willoughby has filed a motion to revoke Mr. Henderson's bond that was filed yesterday. Of course, I would like a little time to discuss that with Mr. Henderson. If we could, I know we had talked about potentially Thursday, maybe hearing that, or we could put it in May, whatever Your Honor would like to do, but I would want to move forward on
If
that.
the case is set in front of me, then it seems to me I need to be the one to hear the bond motion, so
That's fair.
in my opinion, we'll hear it today, this afternoon if necessary, and if you need time more than that, I can give you Thursday at 9 o'clock.
I'd ask for Thursday, Judge.
State have any opposition? All right, we'll, Ms. Pam, we were supposed to be here Thursday anyway, Ms. Billingsley, you have any problem with being here for this? All right.
No.
We'll hear the motion to vote bond on Thursday morning at 9 o'clock.
Thank you.
Terrence Jr. Biggs.
This is the second call for Mr. Biggs. As noted before, this is Ms. Sunny Stevens' case appointed on this matter. We had a settlement resolution on this over a month ago in February. We asked for this to be placed on this docket. My understanding is Mr. Biggs knew to be here on that based on his acceptance of that. I spoke to Ms. Stevens yesterday. Ms. Margaret Brady's here standing in for her, and I told Ms. Stevens yesterday by phone that if he did not appear, I would request a capias in this matter due to his failure to appear. So that's what I'm requesting at this time, sir.
Able to speak, Mr. Biggs, of course, I would ask for you to be able to reach out to him and see what motion.
Well, there was a court order for it to be set for today, so therefore his failure to appear is a violation of the court's order, so I will order that a conditional forfeiture of his bond. Conditional forfeiture of his bond in the amount of $17,000. Capias for the defendant. Certification of the bonding company set March. We need to set it on September VOP day. September 30th for final forfeiture, and the new bond will be $25,000.
Yes, sir. Thank you.
All right. Other than the second calls that we have, is there anyone who has anything in this court that your name is not being called?
I don't have any name.
Mr. Lockhart, do you have something
I have an arraignment
on who?
On Philip J. Stanfield, which is page 5 of the docket number 2025 CR 19699.
All right, you represent Mr. Stanfield.
Mr. Eric Lockett and I do, Your Honor. We waive a formal reading, enter a plea of not guilty.
Plea of not guilty is entered. You want to set it for status,
I'm gonna bring him up here, Your Honor.
so it would be April 15th. All right, Mr. Stanfield, I'm setting a plea of not guilty has been entered, and I'm setting a status date in front of the next judge in the Judge General Segi's case, so it will be April 15th.
Yes, sir. Thank you, Your Honor.
Thank you.
Yeah, we'll know the face. Your Honor, and then, in addition, on page 5, docket number 19319, James Standifer that I announced was for hearing. We have settled that. And you'd advised the officers to bring him in court. We can do it by Zoom or whatever is easier for
We've
the
already
court.
gotten out of the Zoom, so they just need to bring him up. So,
All right.
all right. You have something I can take up?
Yes, Your Honor, just acknowledging note from Mr. Jerry, and it's at least on page 3 of Your Honor's docket.
We can do a plea on that matter.
Right, and what are we doing with him?
We'll be entering
All right.
please, no contest, please.
I've been handed a document indicating he's going to enter a plea of no contest, and that count 1 of that charge would be aggravated assault. He would receive a sentence of 5 years suspended to supervised probation. Count 2 would be the same, 5 years suspended to state probation. Count 3, theft, would be 5 years suspended to state probation, $8,000 restitution, and that is reserved
For a hearing, yes.
for a hearing. Okay, and that counts, the remaining counts would be dismissed. You would get pre-sentence jail credits according to this document. This, all right, Mr. Henson, raise your right hand. Let's place you under oath. State your, you can put your hand down now. State your full name for the record.
Gary Wayne Henson.
Mr. Henson, I'm going to go over your rights with you, so when I ask you a question, make sure that you understand it and answer it out loud, okay? Mr. Henson, you're here today charged with a number of different counts, but it's been indicated you're going to be entering a plea of no contest or nolo contendere. What that means is that you may have heard me explain, you're not going to admit you did anything, but you're not going to contest the state's evidence when they give it to me, and I will use their evidence to find you guilty of these charges that you're pleading to. Do you understand that?
Yes, sir.
Do you understand, however, that what you're charged with, and have you and your lawyer been able to go over these charges and discuss them, and do you feel like you understand the nature of the charges and the range of punishment you're facing?
Yes, sir.
Well, it's indicated that you want to plead no contest. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand if you went to trial, you would have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, sir.
Do you understand that trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called against you, and you can bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand you would be presumed to be innocent. You would not have to testify at trial, and no inference of guilt would arise because you did not testify or prove anything at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyer worked out.
Yes, sir.
But you understand that's going to result in 3 serious felony convictions that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead no contest and waive your right to a trial?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do you understand that I can't accept your plea unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges?
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Yes, sir.
Gentlemen?
Yes, Your Honor, on January 1st, 2024. 29564. Deputies from the Chief County Sheriff's Office responded for 1449 Valley Road here in Cheatham County to a drive-by shooting. There were several victims in an occupied dwelling, saying that several rounds, I believe at least 6, were fired at the residence. While officers were out there, the victim described a dark and colored Dodge Durango as the suspect vehicle. While on scene, that same vehicle drove back by, ended up in a high-speed chase, and eventually they were spiked out, and Mr. Henson was one of the occupants of that vehicle. out of abundance of caution, just the incident report and the warrant says they recovered some weapons. So if we could add that those weapons would be forfeited to the Chief County Sheriff's Office. Mr. Brogan, the co-defendant, I've added his plea agreement, but Mr. Atchison went to go get his diversion out of the building.
I'm not asking that you agree with those, facts, but do you understand that's what the state's evidence would be if this case went went to trial?
Yes, sir.
You still wish to enter a plea according to this agreement?
Yes, sir.
Are you satisfied with your attorney services?
Yes, sir.
Do you believe that Mr. Montenegro, however, I'm sorry, I apologize for, how do you pronounce it?
It's Montanino.
Montanino. Mr. Montanino has done a good job of representing you competently.
Yes, sir.
Mr. Montanino, do you know of any reason you should not enter this plea?
No, I do not.
And Gary W., anything further from the state? All right, then Gary W. Henson, docket number 19564, upon your plea of no contest to count one, I find you guilty of aggravated assault, sentence you to 5 years, Tennessee Department of Corrections, that will be suspended to state probation. Count two, found guilty of aggravated assault, sentenced to 5 years, Tennessee Department of Corrections, suspended to state probation. Count eight, you're found guilty of theft, sentenced to 5 years in the Tennessee Department of Corrections, that will be suspended to state probation. The amount of restitution is $8,000, and that will be reserved. All weapons that were seized are forfeited, at least as to your ownership interest. All the remaining counts are dismissed. You get pre-sentence jail credit supporting the document that is being filed with the court. That's the judgment report. You'll need to see the probation department, please.
Thank you, Your Honor.
All right, thank you. Anybody else have anything that you're ready on before we bring up the inmates? Mr. Vaughn, you said you had some of your defendants are on the front row.
Yes, these are
judges,
my baseball players.
Well, stand up and let's take a look at you. Who plays what position?
Third, short, catcher.
Catcher that's what I was when I played ball, and that's a tough, that's the reason I have bad knees even today, so I wish you the best. Plus you get hit every time somebody swings and misses and you tip a foul ball into you. It's the hardest position to play in the entire game of baseball. But
And one football player retired.
yeah, you got one football player. That's your grandson. Stand up. Let's take a look. Yeah, this is the one the University of Tennessee's already made an offer on.
He's got academic money. He's gonna do power. Done with football.
All right. Well, we'll let you all guys. I hope you learned from this proceeding today to stay out of trouble. So, all right, we'll stand at recess until we bring up the inmate.
All right.
Hey, Paul, it's Curtis today.
I can't either. I can't. Oh, gosh. Oh. If I ever catch Amy in the office, I'll get you. Call her, hey, you in office? Yeah, I go up, I finally get a chance to go up there. What happened? I'm saying, here, just somewhere. Jokers in the shape. Oh, I disagree, this Julie.
It's been, good for me. I'm tired of following that.
It may be a little stressful. It's a little.
It's good. You must have to have those every day.
It's good on.
Yeah, there's. It's part of it. And, that's social knowledge.
Did you play baseball? I'm a fan.
They won it last year. Yeah, they figured out what's going on. Said they caught it. Caught some brains. Yeah, but it's so.
You don't have to be the fastest one in the crowd. You don't have to be slow. Yes. Two of those four are talking about maybe being criminal lawyers. So, yeah. Yeah. May have a future firm right there.
What about James? Is he one?
He wants to be a lawyer. Yeah. Totally. He wants to practice with Papa. If Papa lasts that long in practice. I got to practice with my dad 3 years ago. And I really wouldn't take anything for it. I got to try cases in front of Judge Spencer. Yeah, tried a divorce case in front of him with Alan Kearns. And Judge Spencer, I represented the wife, and the husband was trying to have assets. Judge Spencer called on him, he gave the wife everything. Then at the end, he hadn't ruled in regard to the pickup truck that the guy had on their dairy. And Alan Kearns said, well, I'll see you on it. My client would be able to keep his pickup truck that he uses on the deck. I said, no, I'm giving that to the wife. Kearns, he was so crestfallen. But Judge Spencer would sit up there and give that unlit cigar in his mouth. He would chew on the end of the cigarette the whole time. Yeah. He served, can't remember if it was the Senate or the House in Nashville for a number of years in, I believe in the 40s. Yeah. No, that was Bill McMillan. No, Bill, no, yeah. Yeah. The jury box was over here. And then the bench was right there because we didn't have the jail at the time. And you can, you might be able to see a circular piece of tin over in that corner. There were 4 holes that had pot-bellied stoves in each corner. Yeah, yeah. And I know Dad was prosecuting a first-degree murder case here in the 65 or something like that. Courtroom was full, and they had the windows open so that people could try to stand outside and hear some. Court was a big deal. Yeah, yeah, yeah. Yes.
You ever dealt with a case, you ever filed anything in a motion because they charged somebody with possession when they didn't have the guard? They just admitted to using it.
But they didn't find any around them at all.
The juvenile in high school, and I understand it. He gets up for being under the influence in school, gets in trouble. But they keep charging with possession when he didn't possess.
No.
He admitted to use it. He's in the argument to use it to have it possessed. He didn't.
Right. Did he give them a statement that he had been carrying it?
No, he told them that he had used it.
Yeah.
But all they've got. So they made him, he wrote a statement, they made him redo it and write it the way they wanted him to.
Ah. Yeah, I would
I'm
argue that the petition, even as stated, does not state a criminal offense of possession.
Nope.
Because it doesn't allege
That he possessed.
that he possessed.
And they never saw him possess it.
You have the petition with you?
No. I'm gonna argue it, see what they do with it. And to be honest, we were agreeable with him doing all the stuff that he needed to do.
Yes, yes.
And then, but that it be dismissed.
Yeah, yeah.
But he refused to do that.
Really?
Yep.
Tommy can be.
It just made no sense to me.
I like him.
I know. I don't dislike him. It's just,
No, I do.
we're getting what we want. This child needs to be, stop doing, not do this, but we get the punishment, but. And they said, well, you can get it expunged later. I said, how do we know who the judge will be that will agree to it?
Right,
I
right,
can't guarantee these people that it will.
right.
So anyway,
Won't he do it as a, conditional plea or informal adjudication that allows him to
he
explain?
tried to do that.
Ah,
He wouldn't agree to nothing. So everybody's hearing what I say.
oh,
I didn't say nothing.
Julie just reminded me,
Simply this, it's rocky club, they're doing this in hobby, they're working on a liquid fuel and they test. Said they might not have the largest student. Rocket at the moment, that's the largest student building.
That's awesome.
Burn. Yeah.
So what am I getting?
I did non-meth because that has a 30-day.
So do you want me to?
No, that's fine.
Okay,
Because that's what he was charged with. That's
originally,
what he
right.
collected.
Okay, thank you.
Hi, you enjoying it out here?
Yeah.
I know, right? I know, good. I got to. That's so good to you sit over here.
Yeah.
The end of the day, it's like a very long Richie, they're there for 3 days. I think the competition maybe starts Friday or Sunday. You know.
Oh, that's.
That's.
When you finish.
You gotta have training. Yeah.
They did the first. They did that good too, and when they fix everybody else. But, and I did get a mission. So, you know.
It's on. It's streaming on YouTube. About this one. Yeah, but if I do that, I'm sorry, that'd be cool.
Yes, absolutely.
All rise. Court's back in session. Be seated, please.
Mr. Atchison, you have something you need signed.
Should have done it.
I don't think signed one of this. This is a different defendant.
Same case. This one hasn't played yet, but.
All right, we have one inmate.
It's, page number 2, docket number 19474, Brianna Cox.
Judge, I represent Ms. Cox. She's here on BOP. I spoke to General Willoughby and he has agreed. She's going to admit that she's in violation of her probation. She's going to be reinstated.
All right, Ms. Cox, raise your right hand. Let's place you under oath.
Yes,
That's your full name for the record.
Brianna Keith
You can
Cox.
put your hand down now.
Okay.
Ms. Cox, you're here today charged with probation violation. Do you understand that you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard of, that you had violated your probation? And that if we had that hearing, you would have the right to have a lawyer and have one appointed for you?
Yes, sir.
Do you understand that if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes,
You
sir.
understand that? Do you understand that if you enter this plea of guilty to the violation of probation, you're waiving your right to that hearing, to that appeal? All I will be doing is to approve what your lawyer has worked out with the state.
Yes,
You
sir.
understand that? You understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty to the charge of probation violation according to this agreement?
Yes, sir.
Then upon your plea of guilty, I find you guilty, or that you be revoked to serve your sentence, but by agreement with the state, you'll be reinstated to probation on time served. And you will be on probation for the remainder. This is a one-shot deal, so if you violate your probation again, you will serve your sentence entirely.
Yes,
You
sir.
understand that? All right, thank you. You guys moved out of my line of sight to avoid getting embarrassed again, is that it? You're smart. Anybody else here in the courtroom that has something that I can take care of? Mr. Atchison?
There's a matter of State v. Jonathan Brewington.
I'm sorry, who?
Jonathan Brewington,
Okay.
case number 19564, Judge.
On page 1.
Trying to be proactive, Judge, and give it to the patient beforehand. Judge, I'm gonna pass forward a plea sheet in Mr. Brewington's case. And also, Judge, the TBI diversion, which has been ran. We're going to be entering this plea under 4035-313.
All right, I've been handed a document indicating that Mr. Brewington is going to be entering a plea under Tennessee Code annotated 4035-313, also called judicial diversion. It would be a no contest plea to count one. He would receive a sentence of 5 years, Department of Corrections suspended to supervised probation, pay the court costs, credit for time served, count 2, 5 years. Department of Corrections suspended to supervised probation as a range 1 offender. It would be concurrent with count 1. Count 8 would be 5 years. Tennessee Department of Corrections suspended to probation as range 1 offender, reserved restitution. That would be concurrent to all of the other counts, and no contact with the victim. Counts 3 through 7 would be dismissed as a part of the agreement. Mr. Brewington, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Jonathan Scott Brewington.
Mr. Brewington, you're here today with a number of different counts in an indictment. I want to make sure that you understand everything. Do you understand what you're charged with? Have you and Mr. Atchison had a chance to talk about these charges, discuss the range of punishment you're facing, as well as any possible offenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere. That simply means you're not going to admit anything, but you're not going to contest the state's evidence. And as a result, the state will tell me what their evidence would be, and that evidence will support my finding of guilt in this case. However, what we are doing also is because you have no prior record that these pleas are being entered under an agreement or a statute rather that allows me to place you on probation for a period of time. And at the end of that probation, if you've done everything you're supposed to do, you can apply to have your record expunged.
Yes, sir.
But if you don't do that, then you can be brought back before me or one of the other judges, and you could be resentenced. It would become a permanent conviction, and it would be resentenced according to the law within the range of punishment that the law applies for that. You understand that?
Yes, sir.
So not only would you be made to serve the sentence, but you would also you could potentially get a larger sentence. You understand everything? Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that I need you to speak up because we're recording all of this. You understand that you would have the right to have a lawyer if you went to trial and have one appointed for you if you could not afford your own.
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you without appeal?
Yes, sir.
Do you understand by entering this plea, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out.
Yes, sir.
Now, I've explained to you that a plea under 4035-313, also referred to as judicial diversion, means you're going to be sentenced, you're going to be placed on probation for 5 years. And that will be going into a file, and for 5 years, we're going to monitor how you do. If you successfully complete your probation, do everything you're supposed to do, stay out of trouble, then at the end of that time, you will have the right to seek to have it expunged from your record. It won't happen automatically.
Yes, sir.
You'll have to apply for it. But by converse, as I explained to you, if you violate the terms of your probation, then this will become a permanent conviction. These 3 felony convictions would become permanent convictions on your record and would be there in the future to make more severe the punishment you receive if you're ever again convicted of a crime. In addition to that, you would be likely to have to serve those 5-year sentences in prison. Do you understand that? Now,
Yes,
how old
sir.
are you? 19. You're 19 years old. So you'd be 24 by the time you got out of prison at 5 years. You understand that?
Yes, sir.
I can guarantee you, I don't think you would enjoy going to prison as a young man at 19 years of age.
No, sir.
So you better learn from this experience if you will speak.
Yes, sir.
But you understand that what I've explained to you about this.
Yes, sir.
All right. Do you still wish to waive your right to a trial by entering the plea under the statute?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
Do You understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty of this charge.
Yes, sir.
And listen as Mr. Willoughby tells us what the evidence would be. I don't know if that microphone works there on the bench or not, but that's all right.
In docket 19564 on January 1st, 2024, officers responded to 1449 Valley View Road here in Cheatham County, Tennessee, in reference to a drive-by shooting. There were several individuals in the residence there that was shot at multiple times. The description of the vehicle was a dark in color Dodge Durango, I believe. While officers and deputies were on scene, that same vehicle did drive back by. Officers got into a high-speed pursuit. The vehicle was eventually spiked, and 4 occupants got out of the vehicle. Only 2 were apprehended, one of which was Mr. Brood.
All right, you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to enter a plea of no contest?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
You feel like Mr. Atchison's done a good job of representing you competently?
Yes, sir.
You know of any reason you should not enter this plea?
I do not, Judge.
Anything further from the state?
No, Your Honor.
Do we need to also show the weapons are forfeited? It is shown on here. The weapons are forfeited to the Cheatham County Sheriff's Office. Mr. Brewington, I know you're 19 years of age, and sometimes you see things on television or you see things in games that you might play that seem like that's not a big deal. Firing a weapon into a house, and I'm not saying you're the one that did it, but being in a carload of people who fire into a house, you very easily could be facing a charge of second-degree or first-degree murder, in which case you would be spending a large part, if not the rest of your life, in prison. Certain decisions you make, even as a young man, can carry terrible repercussions for both you and the people who were involved in it.
Yes, sir.
I'm assuming you wouldn't want people shooting into your house when they drove by.
No, sir.
So you understand that this, what a terrible decision this was, and that you are, only because you have no prior criminal record, are you being given the opportunity to keep this off of your record.
Yes, sir.
Because otherwise you would have 3 felony convictions like the other gentleman who's already disposed of his case. And he can't take those off his record.
Yes, sir.
I hope you will learn from this lesson, and I will find you under this agreement. I'm ordering that in count 1, on your plea of no contest, you are ordered to be placed on probation for 5 years with the Tennessee Department of Corrections. And count 2, you're found to be placed on probation for 5 years with the Department of Corrections. And count 8, you're also found to be placed on probation for 5 years with the Tennessee Department of Corrections. All of that will be supervised. All of that will be concurrent. And the restitution issue is reserved to have no contact with the victims, and the weapons that were recovered are forfeited. The pre-sentence jail credits are set forth on this document. All right, thank you. See the probation department.
And Judge, if we possibly set that restitution matter in July while Mr. Brewington.
That's fine. Set it on the July VOP days. You want to do that? This is July 29th, 7th. July 22nd for the VOP day. Mr. Vaughn, you have anything, what about, who do we have here?
I've got all 3 of them.
All
I
right,
have on page number 1, docket number 19006, prison for Gracie.
Judge, we spoke about Mr. Bracy. He's the individual that's filling out a drug court application. And they'll be voting on tonight. I met with Mr. Beach this morning. I believe we already said it on
4:15.
4:15.
So we're gonna see what happens with your drug court application, and we'll bring you back in front of a different judge on April 15th.
Thank you.
Next, inmate.
All right, the page number 3, docket number 19309, Mr. Jenkins.
Judge, this was one that we did have worked out. And his probation officer indicated that there was a new amended VOP that it needs to be served with, indicating some other charges elsewhere.
I believe we've already arraigned him on his behalf, stood in for an arraignment, but we will appoint you on this amended violation of probation warrant set up for May 27th.
Understood. I'll put that, see.
Is this on 527? 516? 27, we have different, 27.
Page number 3, docket number 19363, Drake McCroskey.
Judge, I represent Mr. McCroskey. We've come to an agreement on that. Mr. McCroskey is going to plead that he is guilty of violating his probation. And by agreement, he is going to be transferred to community corrections. I believe he's supervised out of Rutherford County.
All right, raise your right hand, Mr. McCoskey.
Yes, ma'am, I do.
State your full name for the record.
Drake Alexander McCroskey.
Mr. McCroskey, you're here today charged with probation violation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, Your Honor.
You understand that you would have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, sir.
You understand that if you had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir, Your Honor, I do.
You understand that by entering this plea of guilty, you're waiving your right to that hearing and that appeal?
Yes, sir.
All I'm
Your
going to
Honor, I
do is to approve what your lawyers worked out.
Yes, sir.
And that means you're going to be revoked to serve your sentence, but then reinstated to probation and transferred to community corrections. You
Yes, sir.
understand that? You understand everything I've explained to you?
Yes, sir, Your Honor, I do.
And you wish
understand.
to enter a plea of guilty according to this agreement and waive your right to that hearing.
Yes, sir, I do.
And upon your plea of guilty, I find you guilty or that you be revoked to serve your sentence, but by agreement with the state, I will reinstate you to probation and transfer you to community corrections for the balance of your sentence.
Yes, sir,
All
Your
right,
Honor.
thank you.
Thank you. Appreciate it.
Thank you, ma'am.
Your Honor, I have a disposition on Mr. Standiford.
Okay.
If I could announce that, I've got to get to Williamson County Court. I appreciate it.
All right, this is on page 5, 2022, CR 19319, James Clay Standifer.
Your Honor, he's going to be pleading guilty to the violation. He'll be sentenced to 6 years, suspended after 7 months. This will run concurrent with Davidson County. And by way of explanation, the charge here was before Davidson, and Davidson did not see fit to make it consecutive. So that's the reason we're doing what we're doing. As a condition of his probation, he'll have to complete the Men of Valor treatment program.
So he's already been sentenced. The total this shows he was sentenced to 4 years in the Department of Corrections. Is there,
I'm sorry. I was thinking, was it 6 or 4? 4, I'm sorry, 4 years. It'd be 4 years suspended after 7 months, runs
he's gonna be
concurrent.
revoked, excuse me, Mr. Lockett,
Yes, sir.
in the terms that I normally refer to, we're revoking him to serve 7 months and then returning him to probation on a 4-year sentence.
And that's concurrent with Davidson County, where they did the same thing after 7 months and also required Men of Valor treatment.
All right. Raise your right hand. Let's place you under oath, Mr. Standiford.
Yes, ma'am.
State your full name for the record. You can put your hand down.
James Clay Standiford.
Mr. Standiford, you are here today on charge of probation violation. I want to make sure you understand your rights. You understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation.
Yes, sir.
You understand that if you had that hearing, you would have the right to have a lawyer and to have one appointed if you cannot afford one of your own.
Yes, sir.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to that hearing and that appeal? All I'm going to do is approve what your lawyer and the state have agreed upon.
Yes, sir.
And that's that you're going to be revoked to serve 7 months. And following the 7 months, you'll be reinstated to probation. And that will be running concurrently with your Davidson County case. Do you understand that?
Yes, sir.
As a condition of your probation, you're going to be required, once you're released from jail, you're going to be required to attend and complete the Men of Valor program. Do you understand that?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty to the charge of probation violation according to this agreement?
Yes, sir.
Then upon your plea of guilty, I find you guilty, ordered to be revoked to serve 7 months. And then following that 7-month sentence, you will be reinstated to probation. As a condition of your probation, you'll be required to attend and complete the Men of Valor program. This will run concurrently with your Davidson County case. All right,
Yes, sir.
thank you.
And I'll provide the jail credits
All right.
later on. Thank you.
Who's next?
All right, we have on a second call, page number 6, docket number 19702, Jonathan Williams.
I am going to appoint you, since you already represent him, I'm appointing you to represent him on these charges. There was a failure to appear that was issued in this case back on March the 11th. But that failure to appear resulted from his failure to appear here, but he was incarcerated in Dixon County Jail. So I am setting aside that failure to appear.
Based on the failure to appear, the court revoked his bond. I would ask the court to reinstate that bond since.
If he had a bond, I will reinstate that bond. That was the original, that was the new bond on the forfeiture. Did he have a bond before that?
In general session.
Okay, $5,000 with Lloyd Harris. Well, I set aside the failure to appear conditional forfeiture, so the original bond of $5,000 will be reinstated.
Thank you, Your Honor.
Thank you so much.
Oh, we need to put him on a status date.
Yes, Your Honor.
Whose case is this? Just,
Sagis. I
you
think
know,
we,
say, let's put it on the April 15th.
Your Honor,
She requested, June 3rd, I believe.
June 3rd.
June 3rd. Thank you, Your Honor.
Right.
He'll be gone to that furlough is why. Thank you.
Okay. Who's next?
Page number 4, docket number 19413, Clifton Phillips.
Judge, I represent Mr. Phillips. You see here on a violation of misdemeanor probation. He had 2 consecutive 11/29s. He was due off in July. I spoke to his probation officer. He's going to admit that he's in violation and be reinstated.
Raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Lieutenant Lee Phillips, Jr.
Philip, you are here today charged with probation violation. Do you understand you have a right to plead not guilty and to have a hearing in this court where the state will be required to prove to the legal standard that you have violated your probation?
Yes, sir.
Do you understand you would have the right to have a lawyer and have one appointed as I've done with the public defender?
Yes, sir.
Do you understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
Do you understand that by pleading guilty, you're waiving your right to that hearing, to that appeal? All I'm going to do is approve what your lawyers worked out.
Yes, sir.
Do you understand that means that you're going to be reinstated to probation on time served because you're very close to the end of your probationary period? Do you understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you wish to waive your right to a hearing by entering a plea of guilty?
Yes, sir.
And upon your plea of guilty to violation of probation, I order that you be revoked to serve your sentence, but with the agreement of the state and on time served, you'll be reinstated to probation, and you need to see your probation officer as well. So,
Yes, sir.
all right, thank you.
Thank you.
Ready.
All right. I don't have a page number, but it's docket number 19428, Matthew Scarborough.
The new docket number is 19685.
Yes, Judge. So we've got 2 separate things going on. He's got a violation of probation on some new charges he got in Cheatham County. We had a hearing, and Judge Lockhart Mash kind of found that he found that he was in violation, but we were going to try to get drug court. That's not an option since Mr. Scarborough has indicated to me that he just wants to put his sentence into effect and get on to the TDOC. So that's part 1. Part 2 is a plea for the new charges.
All right. You have a plea agreement on that?
I do, Judge. So the plea agreement, he's going to be pleading to count 2. That's amended to attempted aggravated assault, a D felony. He'll get 4 years in the TDOC concurrent with his other Cheatham case. That would be 19428. And then he's also going to be pleading to count 5. It's theft of property, but it's amended down to the D felony variety of 25 to 10,000, from the 10 to 60. He's going to get 2 years to serve in the TDOC consecutive to count 2 of 19685, but concurrent with 19428.
All right. Raise your right hand, Mr. Scarborough.
Yes, ma'am.
State your full name for the record.
Matthew Lee Scarborough.
Mr. Scarborough, you have 2 things I need to deal with. Number 1 is your violation of probation case, which Judge Lockhart Mash heard and basically found you guilty, but violated your probation, but then reset it for a sentencing hearing. It's my understanding that you want to go ahead and put that sentence into effect. Is that correct?
Yes, sir.
All right. Mr. Willoughby and Mr. Vaughn, I'm of the opinion that Judge Lockhart Mash probably needs to sign an order to that effect, simply because of the fact that I've run into this issue before in another case where I took over a matter before Judge Wallace, that Judge Wallace had heard of a plea on and then set it for a sentencing hearing. I came in and thought, well, I need to have him plead in front of me. I then took a plea from the individual and sentenced him. And the Court of Criminal Appeals held that that was completely void because he had already pled in front of a different judge, and that plea was the prevalent plea. So I think what we need to do is just show that he's requesting to put it into effect and have Judge Lockhart Mash sign off on that.
Understood. We can certainly.
The other case I can take care of on docket number 19685. It's been indicated you want to enter a plea of no contest to the amended charge of attempted aggravated assault and a theft of property. Do you understand that a plea of no contest means that, or nolo contendere means that you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when they give it to me in a little bit. And I'm going to use that evidence to find you guilty according to this agreement. Do you understand that?
Yes, sir.
You understand, however, what you're charged with, and if you and Mr. Vaughn had an opportunity to discuss these charges, and do you feel like you understand what your range of punishment is and what the possible defenses you might have to the state evidence?
Yes, sir.
Well, it's indicated you want to enter this plea of no contest. Do you understand you can plead not guilty and have a speedy and public trial by jury?
Yes, sir.
Do you understand at trial you would have the right to have a lawyer and to have one appointed if you could not afford your own?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything.
Yes, sir.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand at trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
Do you understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out.
Yes, sir.
Do you understand that's going to result in 2 convictions, both felonies, and those are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes.
You understand that I'm giving you sentences of 4 years in one case and 2 years in another. How much of that sentence you serve is up to the Department of Corrections. I'm giving you these 2 sentences, and they're going to have to determine whether or not you get, other than pre-sentence jail credits, it'll be up to them on good time and other credits that you earn towards that. Do you understand that?
All right.
You understand everything I've explained to you?
I do.
Do you want to plead no contest according to this agreement and give up your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No.
You understand I can't accept your plea unless I'm satisfied you are guilty of these charges and the facts are there to support that.
Yes, sir.
And listen to the state as they tell me what their evidence would be at trial.
Yes, Your Honor. In docket 19685 on October 3rd, 2024, deputies responded to 304 Ed Harris Road here in Cheatham County to a vehicle crash. Witnesses on scene advised that the occupant of that vehicle, one mentioned that they saw a firearm and that he fled into a wooded area. Lieutenant Shannon Heflin with the Cheatham County Sheriff's Office got with a security personnel who was on that property. I believe they were somehow involved with this Ryan Upchurch, who I think has a music career from here. He was security for him. They got on some sort of off-terrain vehicle, ATV, and went into the area. They said the defendant fled. Once they got to a wood line, I believe they were in a field. They saw an individual unknown to them coming in and out. They were unable to determine whether he was armed or not. I believe he was yelling at them. Shots were fired in his direction. Eventually, I believe he was taken into custody. Post Miranda, he did admit to officers that he was in the wood line. He was, I believe, the occupant of the vehicle, and he was attempting to basically commit suicide by police. A weapon was not recovered, although the deputies did look for one.
I'm not asking that you agree with those facts, Mr. Scarborough, but you understand that's what the state's evidence would be if you went to trial.
I understand that's what they're saying.
All right. Are you satisfied with your attorney services?
Yes.
You feel like Mr. Vaughn's done a good job of representing you competently?
Yes, I do.
Mr. Vaughn, you know of any reason you should not enter this plea?
I don't.
Anything further from the state?
No, Your Honor.
Then Matthew Scarborough, in docket number 19685, upon your plea of no contest to count 2, an amended charge of attempted aggravated assault, I find you guilty, sentence you to 4 years, Tennessee Department of Corrections, that will be served concurrently with other Cheatham County cases that you have to serve, docket number 19428. Count 5, you're found guilty of theft of property and sentenced to 2 years in the Tennessee Department of Corrections. That will be consecutive to count 2, but concurrent with your other Cheatham County case. And that will be, you'll get pre-sentence jail credits according to this document. Thank you.
And I suppose, judges, for jail credit purposes, so I guess those are still being counted until Judge Lockhart Mash is signs and order stamped?
Yes.
Okay,
All right.
thank you, Judge.
Thank you. We have another inmate.
Yes, sir, we have the. I'm ready.
Judge, I represent Mr. Porter. I believe that's going to be for hearing.
For the record, we're calling Roderick Davidson with the probation. Do you mind spelling your last name?
Davison.
And where are you currently employed?
State of Tennessee Probation and Parole.
And are you assigned to supervise Mr. Porter?
Yes, sir.
And this is not his first violation, if I'm correct in reading the file. Is that correct?
That's correct.
What was his first violation for?
He tested positive for methamphetamine on 3/9/23.
Did he have some other charges eventually in there as well?
Yes, he, second violation was, he was arrested in Davidson County for aggravated, burglary and theft of property.
And
And his third, the next violation, he was arrested in Greenbrier, Tennessee for the charge of methamphetamine, sale, manufacturing, delivery, possession with intent, and driving on revoke and drug paraphernalia.
so when it comes to the first two, I believe those were disposed of, and Mr. Porter, was he reinstated?
Yes, sir, that's correct.
And do you know what date he was reinstated?
He was reinstated.
They need to get y'all a little desk for your stuff.
He appeared here in Cheatham County on July 31st, 2024, reinstated back to probation.
And what was the arrest date in Greenbrier?
Oil 6/24 for charge of methamphetamine, driving on revoke and drug paraphernalia.
So roughly 5 months after being reinstated, he got arrested again.
That's correct.
Do you know if those charges have been disposed of?
Yes, he pleaded guilty on December the 3rd, 2024 to driving on revoke second, and he pleaded guilty to a lesser charge. He received 1129 probations, 30 days, 32 hours of public service work, alcohol and drug assessment, and to follow the recommendations.
Other than these new charges, did he regularly report to you and
Yes,
pass drug screens in that 5 months?
that's right.
So other than him having now new convictions, did you have an issue with Mr.
No,
Porter?
sir.
That's all I have.
Ron, you have a question?
I have a couple, Judge, follow up.
No, fine, sir.
Okay, so let's go back in time to figure out exactly. Mr. Porter's, when was he put on your case?
He pleaded January the 9th, 2023 to 4-year sentence with theft of property here in Cheatham.
Okay, so that was in 2023?
Yes,
Okay. So from 2023, and then when was his first violation?
his first violation was during, he tested positive 5/9 with methamphetamine. 5/9/23, excuse me, 5/9/23.
Okay, so he's on there for about 4 months?
Yes.
And tested positive for meth, you violated it.
Actually, he tested positive, yes, exactly, yes. 2 months.
But there were no new charges at that point, is that
No,
right?
no new charges.
Okay. So that was in the July of 23? And then was there another violation?
Yes, he was arrested in Davidson County, on 8/2/23 for the charge of burglary, aggravated, theft of property.
Okay, so was that a second violation?
Yes,
Okay. And then that's when he was reinstated with the special conditions about public service work and things of that
yes,
nature.
sir.
Did he complete the public service work?
I'm not seeing anything in in this file that he
Okay.
completed.
So on the first and second violation, were those both positive methamphetamine tests?
For the first violation.
Yes.
Yes.
At any point, did you consider offering Mr. Porter any kind of assistance with some kind of drug treatment or any, was that a part of a stipulation of him being reinstated?
No, well, after the second violation, he was transferred. He moved to Davidson County. So I no
Okay.
longer supervising him, but I picked him back up when I transferred him. I did a home visit on 8/22/24, but there was no treatments or plans during that time.
Did he indicate to you that he had a problem with addiction to methamphetamine or anything
No.
like that? Other than the failed drug screens, did he ask for that?
No, not to me.
And you said that he successfully reported from
Yes.
July to this past December?
Yes.
Okay.
Yes. Home visits were successful. I mean,
Okay. Did he, was he coming in monthly reporting?
Not monthly. not
Okay.
monthly.
Okay. And he passed his drug screens then as well?
Yes,
Okay. So really it was just the issue on driving unrevoked and the December arrest or plea for simple possession of methamphetamine.
yes, in Roberts County.
Okay. So outside of the new charges, Mr. Porter was doing everything that you had asked him to.
Yes.
Okay. Was he working?
No, he receives disability. That's,
Okay.
that's his sole income.
Okay. Would you be opposed to Mr. Porter getting some sort of help for drug treatment?
No.
Okay. That's all I've got.
So he was originally found guilty of probation violation by me. And in July of last year, when I entered that order finding him to be in probation violation, reinstated him with probation, that was based on the fact that he had tested positive for methamphetamine, but he had new charges of burglary. Do you know what happened to those burglary charges?
He pleaded guilty, sir, in Davidson County. I don't know the outcome, but it was on 3/13/24 for the aggravated burglary. It was a guilty plea. I think the theft of property was dismissed, I believe, but he did plead guilty to that.
And then this newest affidavit is also based on the fact that he has possession. He has been charged in Greenbrier, Tennessee back in November.
Yes, sir.
Did I understand he's disposed of those charges by?
That's
plea?
correct, sir. Yes, sir.
So he's been found guilty of two different violations of the law while he's been on probation.
Yes, sir.
All right, anything further?
Not for me, Judge.
Thank you. Step down. You may call your next witness.
That's all from the state.
I'd call Mr. Porter, Judge.
Porter, come around, raise your right hand and place under oath.
All right, would you state your name and spell your last name for the record, sir?
Joshua D. Porter, Porter.
Okay, Mr. Porter, so you've heard Mr. Davison's testimony as to your reporting status. Would you agree that that's a fair rendition of your probation?
Yes, sir.
So you were put on in January of 2023, is that correct?
Yes, sir.
And then pretty quick out of the gate, we stumbled around in May of 2023.
Yes,
Is that
sir.
correct?
Yes, sir.
Do you have a problem with methamphetamine, Mr. Porter?
Yes, and I like help.
Okay,
I really do.
okay. Are you just saying that because you're sitting here in Orange and now you're in jail?
No, I mean, I've lost my family and everything because of it, and I really do need help.
You think you might be getting a little too old to be doing this, sir?
Yes, sir, I do.
Do you have any violent felonies on your record that would prevent you from going into a treatment program?
No, sir.
Would you be open to our drug court program if you were eligible?
Yes, sir.
You understand that that's an 18-month program
Yes, sir, I do.
and that you'd rather do something like that than sit in jail for the next 2 years. Is
Yes,
that right?
Yes, sir.
How old were you when you first started using?
15,
15, and you're how old now?
49.
Okay. Were you working, Mr. Davidson indicated that you received disability. Were you working when all of this happened?
Yes, and the last charge I was doing a tree job in Greenbrier. Just had got done, leaving, going on, got pulled over for no driver's license.
What's the disability with which you suffer from?
A TBI, traumatic brain injury.
Okay, when did that occur?
I believe it was in 2011.
Okay, how did that occur?
A tree fell and crushed my head.
Okay. Does that still bother and affect you to this day?
Yeah, I have seizures and currently epileptic cause of it.
Okay, are you allowed to take your epilepsy medication in the jail?
Yes, sir.
Do you think that they're able to help you treat your TBI properly?
Not really, because I don't get all my bipolar and PTSD meds. or
Okay,
nothing
so
like
so
that.
there are some medications that you are typically on that you do not receive in the jail.
Yes, sir.
Okay. I assume General Willoughby is going to look at this as your third, possibly even fourth chance. Why, will you tell this judge why you deserve that, Mr. Porter?
I'm an honest guy, and I just want to do better. I had another chance to prove myself.
I'll pass, Judge.
I was looking on Davidson County's clerk's website. You pled to aggravated burglary,
Yes, sir.
and that was after you were reinstated here?
No,
Before?
yeah,
What did you get in Davidson County sentence wise?
it was a 6 run concurrent with Cheatham,
So 6 there and then 6 here,
4,
6 and 4, total of 6.
yeah.
So again, I think Mr. Vaughn's right. So this is technically like your fourth chance, at least in Cheatham County. Have they filed a violation on you in Davidson?
No,
Do you have a probation officer down there now, or are you back
No.
to meeting with
No.
Mr. Davidson?
I can meet Mr. Davidson.
Okay, and since you pled, what, did you break in a house?
No, it is the same charge.
No, in Davidson County, you
It's
took
the
a,
same charge, the one that was here in Cheatham.
you pled to aggravated burglary.
Yeah,
So the way you get to aggravated burglary is to break in someone's home.
that's what they said, but I didn't break in nobody's home.
Then why'd you plead to it?
I pled to having the stolen property.
So you had stolen stuff.
Yeah, that's the
Okay.
same thing I'm here, the same charge from here.
You had stolen property that was stolen out of 2 different counties.
No, charge I have here is the same one from Metro. It's the same property.
That's what I'm saying. So some of that property was stolen from a home here and some of it was stolen in Metro.
No, I got caught here with the property, but the stuff come from Metro.
Okay. I'm tracking now. So I guess my last question is, you say you're an honest guy, then why do you have a bunch of stolen property?
Really don't, know. I mean, I was messed up on drugs.
That can
Pretty bad on
affect your
drugs.
honesty, right?
Pretty
Right?
ba- Yeah,
Okay.
I was pretty bad on drugs.
I don't have any other questions.
Nothing from me either, Judge.
All right, thank you. You can sit down. Do you have any other witnesses?
I do not, Judge.
Do you have any rebuttal proof?
I do not.
Wish to be heard in argument?
I think everybody knows what I'm gonna say. I think Mr. Porter's had plenty of opportunity, and for whatever reason, and I guess 30 some odd years, he's been unable to kick a methamphetamine habit, and those have resulted in him hurting other people by having their stolen property or possibly breaking into homes or being in concert with people who do. And I think it's just time for him to be revoked.
Well,
Briefly, Judge, I mean, you heard the man say that he's pretty fed up with it. To hear he's 49, only 49 years old is surprising to me. I think that's still plenty of time for Mr. Porter to turn his life around. I know that we've got some pretty great treatment programs here and around, and I don't know if an aggravated burglary would disqualify you from drug court. But I understand what number of chants that were on for Mr. Porter, but as he said, and I'll let his testimony stand on that, we would ask for one more so we can actually address the problem. It sounds like we were doing what we were supposed to throughout our probation, aside from getting new charges and aside from being the victim of a drug habit that's been going on since he was 15. I think that Mr. Porter is ready to address what the real issue is. You obviously heard that he's got some medical issues with traumatic brain injury that are not being treated as they should inside the jail. We would ask that we be reinstated or transferred to community corrections or make some sort of long-term treatment program a part of this so we can put all this behind us and finally be done with the methamphetamine habit, Judge.
Mr. Porter was found guilty by me in a plea agreement that was entered in January of 2023 to the charge of theft of property and sentences to 4 years as a range one offender. It's following the entry of that judgment, within just a few months, he had violated his probation and a warrant was issued in May 9th of 2023 by Judge Lockhart Nash. And that he had tested positive for methamphetamine and amphetamine and had failed to provide proof of his disability. I believe that another charge of violation of probation, no, I'm sorry, that was the same, that was just a copy. So then the matter came before me, and it was an amended one actually that was filed at that point, where he was charged with having been found guilty of burglary, aggravated, or was charged rather with burglary and acting in concert, aggravated burglary of a habitation and theft of property. And despite all those things, he came before me in July of 2024 and was found guilty of violating his probation, and for whatever reason, whether it was by agreement or otherwise, he was reinstated to probation, and I signed off on it. And then since he was reinstated to probation, he's now been arrested for possession of methamphetamine and drug paraphernalia, and has pled guilty both to the aggravated burglary charge as well as to this possession charge, and now seeks to have what would, in this court's opinion, be a third chance or a third bite at the apple, third chance, third opportunity to try to address this problem. I'm of the opinion that Mr. Porter is not deserving of an additional chance for probation because, number one, seems to me that the problem is that even though he's on probation, he's still taking advantage of other people, committing crimes against other people, including the burglary charge, stealing property from others. And there comes a point where the court runs out of, as I started to say, I'm fresh out of chances to give him another chance. But it really does boil down to there's a balance between giving someone an opportunity to deal with their issues, putting someone back on the street who has shown no inclination of trying to deal with their issues, because meth has always been obviously a part of the problem in this case. And someone who's shown no inclination to try to get help for themselves or to do anything regarding that, but yet takes advantage by committing crimes against other people after being placed back on probation. It becomes a point where this court's obligation runs to protect society as a whole. And as a result of that, I find that Mr. Porter should be revoked the service sentence with credit for time served.
Thank you, Judge.
That is the judgment of the court. Do we have any other inmates? Is that concluding our docket for today? All right. And that concludes our docket for the day. We'll be back here on Thursday, and it's, motions and the, 9 o'clock. Thursday will be our next salary meeting. So.